Okay, welcome back, everyone. So here we are. We are at the, in the red zone, about to hit the goal line of the final presentation for our 33rd Annual Employment Law Seminar. Thanks to all of you for sticking through with us on a WebEx marathon this morning. Our final session is going to cover the Fair Labor Standard Act and regular rate of pay calculations. As we jump into this presentation, as we have done throughout the seminar, please feel free to submit your questions via chat. I'd like to welcome in my colleague, Mark Wagner. Mark is a shareholder in the firm's Salt Lake City office and Lehigh office. And he spends, his practice focuses on counseling and representing clients in virtually all aspects of employment law. So Mark, it's great to have you with us this morning. Thank you very much. I'm going to turn the time to you and let you take it from here.
Thank you, Jason. I really appreciate it. And thank you to everyone who's stuck around. We have saved, I guess, the presentation that deals a little bit with math for right before lunch, but I guess that's slightly better than right after lunch anyway. So I thought maybe it'd be helpful just for real brief little bit of background for the statute. Sometimes understanding a little bit about the statute's purpose or how it got enacted can help in applying it, or at least not getting too caught up in areas of seeming lack of consistency. The Fair Labor Standards Act, which is of course what we're talking about here, originated in President Roosevelt's New Deal. The goal of the statute was one element of trying to help get the country out of the Great Depression. And the way the statute was crafted was to, by putting in place for the largest category of employees, what we talk about, of course, is non-exempt employees, putting in place a maximum hours standard of 40 hours, and then mandating that overtime pay at time and a half be paid for any work over that maximum hours standard. And that gave employers an economic incentive to spread work around rather than having it done by just a few employees that are working outrageous hours, or what people today might consider outrageous hours. But in order to get enacted, it had to take into account a hodgepodge of political considerations and some legal hoops of the time that needed to be considered. The Supreme Court hadn't been particularly friendly towards similar types of statutes in the past. So the end result of this is that you've got a group of very specific rules that you need to learn and follow, but not all rules that you might think should be included, and some that seem to be thrown in. But again, it was kind of a negotiated statute. So if we go on to what is that statutory mandate? That overtime pay requirement, as the statute is worded, is except as otherwise provided in this section of the statute. No employer shall employ any employees for in a work week longer than 40 hours unless that employee receives compensation for all hours in excess of 40 at 1.5 times the regular rate at which the employee is employed. So there's that language, regular rate, and that begs the question, of course, what is the regular rate? So the regular rate includes, generally speaking, all remuneration that's paid to or on behalf of the employee for work performed during the week. And the work performed part is something I emphasize, we'll talk about a little bit as we go through this, but of course including wages, salary, commissions, non-discretionary bonuses. They're things that are expressly mentioned by the statute. It also includes non-cash payments to employees that are made in the form of goods or facilities that have to be valued at the or included in the regular rate, valued at the reasonable cost to the employer or the fair value of those goods or facilities. Then what is excluded from the regular rate of pay? The statute has 8 categories or sets of types of exclusions, and this is an exclusive list, meaning just what it says. If it's not on this list, then it has to be included in the regular rate, again, assuming it's connected to an employee's work. Gifts, first item. The second class or category of items is pay for occasional periods of non-work, like PTO, paid vacation or sick leave, business expense reimbursements, and other similar quote-unquote payments that are not made as compensation for hours of employment. Third category of or grouping of items, discretionary bonuses being the most significant of that, also mentioned by the statute, payments from profit sharing or savings plans, and talent fees. The fourth category, not coming up a whole lot in this context, or at least not questioned much, benefit plan contributions and payments by employers to certain profit sharing plans, etc. Then you have categories 5, 6, and 7, which generally are kind of similar in, well, they're similar, but just address slightly different categories or situations. If an employer has decided to pay non-legally mandated overtime pay, and when I say that too, it's in Utah and under federal law, we just have to worry about the 40 hours per work week. Some states, however, require payments for time in excess of a certain number of hours per day, or for other situations. And in those cases where a state has more restrictive, or in this context more employee-friendly requirements, then those essentially will supersede the Fair Labor Standards Act. You have to go with whichever one is the most beneficial and most protective of the employee in this context. But for Utah and under federal law, if an employer decides to pay some overtime pay for something like more than 8 hours of work in a day, the statute says, or more than 40 hours in a week, that seems a little redundant, or for more than the employee's regular or normal working hours, the premium or a premium portion, well, first of all, I mean, those can be excluded from the regular rate where they're not required. Just the portion, the premium portion of that amount that's over the regular rate, doesn't have to be calculated back into their regular rate. That's also the case with the premium portion of the premium pay for work on a Saturday, Sunday, or holiday, regular day of rest, where the rate is at least 1.5 times the rate of work, rate of pay for work in the non-overtime hours on the other days. And also excludable is the premium portion of premium pay for work outside of regular work hours that are established by contract or collective bargaining agreement, for example. For a regular work day, it's up to 8 hours, or a regular work week up to 40 hours. Again, so long as the rate of pay is at least 1.5 times the rate that is otherwise paid within the regular work day or work week. And then the last one, certain stock-related income, which we won't go into detail here. Then go over, let's talk about what some of these exclusions really mean in a little more detail, at least some of them. The first category, as you remember, is gifts, and somewhat, when is a gift a gift, and that has come up many times, and the answer is when it's really a gift. And what that really boils down to is a matter really of employee expectations. So it has to meet 3 statutory requirements. It has to not be paid under a contract or an agreement. That wouldn't be a gift if it were. It can't be measured by or dependent on the hours worked by the employees or by the production amount, their efficiency, the quality or quantity of their work. And it shouldn't be, and it can't be so large an amount that the employees would consider it a part of their wages. It's, the idea here is generally expectations. And Christmas gifts, you may become, considered actually part of pay and regular rate. If not only, if they were required, of course, under an agreement, but if it's, given every single year and it's a substantial amount of money, and employees have really come to expect that as part of their compensation. Then we'll move on to the next slide. And so then that second category is essentially pay for non-working time, pay in different categories. And there are a number of different categories of this. I mean, of course, the most obvious is vacation pay, sick pay, PTO, and including buybacks of that same kind of time. There's also payments for occasional periods when an employer fails to provide sufficient work. And some employers will provide what is referred to commonly as reporting or show up pay, perhaps something like 4 hours of pay for employees if they show up to work and they're sent home because the machinery is broken down, or a shipment hasn't arrived that was supposed to arrive, or the weather doesn't permit working. Also, kind of longevity or years of service type of bonuses, so long as they're not made pursuant to a collective bargaining agreement or a city ordinance or policy. That's something that worked its way into the regulations and over the course of time based on application of the act by courts and the Department of Labor. Also excluded are sign-on bonuses, at least where they don't have clawback provisions. They also they can fall in the excludable under this pay not for hours of work category. They also can potentially fall under the category of gifts if the bonus payment wasn't made under a contract. And it's not so substantial, again, that the employees would consider it to be part of the wages. Then next slide, Jason. Also excluded in this category is callback pay. Some employers will provide their employees with an additional amount of pay in addition to the time that pay for actually working if they have to respond to a call from the employer to perform extra work that was unanticipated by the employer. Now, this is excludable only where it is, in fact, in addition to the compensation they receive for the time that's actually worked, and provided that the callback wasn't prearranged. And it may be considered prearranged if it's due to a scheduling issue that required the payment essentially, and that scheduling issue was anticipated and could have been reasonably scheduled or taken care of in advance. Then moving on, another category, another portion or type of pay not for time worked in that category is reimbursement for actual or reasonably approximate amount of the expenses an employee incurs while furthering the employer's business. Examples are the things listed here. This is not exclusive, they're just examples. But cell phone bills for work phones, business supplies, reasonable travel expenses, etc. And then moving to the next slide. Some additional items, of course, perks that really have no connection to hours worked or job performance or any other criteria that are linked to quality or quantity of work. So if you have on-premises gym or health service, wellness program, you provide employee discounts, the amounts that are paid on behalf of employees for parking spaces or benefits. Fortunately for employees, tuition payments are excluded. They fall under this category, as does adoption assistance. And then third category that we talked about or mentioned under the statute is our discretionary bonuses. To be considered discretionary, and they have to be truly discretionary. So they have three statutory requirements, and that is that the employer has the sole discretion as of around the end of the period for which the bonus is being paid to determine whether to pay the bonus, to determine how much is going to be the bonus if it is paid, and again, it has to be discretionary. That the sole discretion. It can't be made according to a prior contract or agreement, or even a promise, which can be implicit if it's just something that happens all the time, and employees have come to expect those payments. They know the criteria for them or something like that. So it has to meet this truly discretionary aspect. Then moving to the next one, we've got, let's see, Jason, if you could go to the next slide. There we go. So here's some examples, of course, of discretionary bonuses. Bonuses for overcoming a challenging or stressful situation. Bonuses for employees who make unique, extraordinary efforts that are not, where the bonuses are not awarded according to any sort of pre-established criteria. Employee of the month bonuses, severance bonuses, and referral bonuses for those employees who are not primarily engaged in recruiting. It wouldn't be applicable in this instance, for a headhunter. But if you provide a $25 or a $50 or something, a referral bonus to employees, it has to meet some additional criteria that the employee participation is strictly voluntary. It's not their job to do this, and that the employee's recruitment efforts don't involve a significant amount of time, and the activities are limited to after-hours solicitation done, primarily among their friends, relatives, immediate acquaintances, just as part of their non-work life. Now, some examples of some non-discretionary bonuses. So that's essentially every other type of bonus, a bonus that's based on a predetermined formula, individual or group production bonuses, bonuses for quality and quantity or accuracy of work, bonuses that are announced to the employees to induce them to work more efficiently, attendance bonuses, they're connected to work and employees come to expect them. Safety bonuses fall in the same category, a number of days without any sort of safety incidents. Then we get to these categories 5, 6, and 7 of the 8 categories. And so again, that was for the premium portion of the premium pay, the non-required, non-statutorily required, voluntary overtime payments by employers in these 3 categories of things, for in excess of 8 hours per day being the more common one, or in excess of the employee's normal working hours, or on a Saturday, Sunday, holiday, regular day of rest. Again, this one and the next subcategory require that the premium be at least 1.5 times regular rate for work on other days. And this last subcategory, category, I guess, is the hours outside the hours established by contract or agreement as the normal work day or work week. Again, if the premium rate is at least 1.5 times the regular rate for work during the regular work day or work week. Now, this extra compensation, these 3 categories, may be creditable towards overtime pay under the Fair Labor Standards Act. The other categories of items excluded from the regular rate of pay can't be credited towards overtime. And then there's some questions of just some other types of pay. Where do they fall? On-call pay is one that I've seen is fairly common. Employees might be who are not actually working, maybe being paid, say for example, 4 hours or something at their regular rate, or at some rate per day when they're required to be on standby and available for recall. Is it included in the regular rate? Yes, because it is part of the remuneration paid to employees for their employment, and it doesn't fall within one of the 8 exclusive exclusions listed in the statute. Is it separately counted as hours worked as well as included in the regular rate for overtime calculation purposes? And that answer to that is it depends, which goes to the next slide. And where it's counted is probably, as you might expect, it's when it's actually worked. So if employees are actually called in during part of that day, the portion that is actually worked is not only counted in the regular rate, it is counted as hours worked for determining whether employees are paid overtime, and then determining what that regular rate is for overtime calculation purposes. If it's not actually worked, then it depends on how restrictive the requirements of the on-call time is, or requirement is. If there are a number of requirements that are so restrictive that the employee essentially is locked down and can't use that time for his or her own purposes, then it's essentially it is considered working pay. So or work time, sorry. So then it would of course be included in the regular rate and as counted as hours worked. Contrary, if the employee's personal activities are not significantly restricted, then the hours don't need to be counted as hours worked for determining eligibility for overtime pay or the related portion of the calculations. But again, in all instances, it's included within the regular rate. And so thought it'd be helpful to do some story problems, for lack of a better term, but beginning with some general principles. The general formula that's applied is that first of all, you calculate it on a work week basis. You can't average hours over 2 or more work weeks. An employee, they can be paid on any sort of basis. A non-exempt employee can be paid on a piece rate, salary, commission, any other type of basis. But for purposes of determining the regular rate and corresponding overtime pay, you need to total all of those hours together and convert it to an hourly rate. That conversion, or you take that total, the regular rate is typically calculated by taking that total pay in any given work week and just dividing it by the number of hours that are actually worked during that week, counted as hours worked. And as I mentioned before, with the 3 exceptions noted, that payments that are excluded from the regular rate can't be credited towards overtime compensation under the Fair Labor Standards Act. So then we'll go to some hypotheticals. And next slide. Okay, so here, starting fairly easy, I hope. John earns $10 an hour. He doesn't receive any other compensation. And he works 45 hours in this work week. How much is he entitled to? And I'll give you just a second, and then, but I think this one is basic enough that we probably can flip over. Well, he's entitled to $475. And that's calculated by his total straight time earnings. So he worked 45 hours, and his regular rate is $10 an hour. So you take 45 hours, multiply it by that $10 an hour, and you get $450. Now that's his straight time pay. Then because of that, in this instance, because he doesn't have any other compensation, his hourly rate happens to be the same as his regular rate. So the $450 in total straight time earnings, or his total compensation, divided by 45 hours gives you a $10 hourly rate, which you then can use or regular rate, which you then can use to calculate the overtime portion that he's owed. And he had 5 hours of overtime compensation, and half of $10 an hour, $5 an hour, times those 5 hours gives you $25. And that, of course, as you remember, that the straight time earnings, the time of the time and a half was already calculated up above. So the additional amount of pay for each overtime hour, each of those 5 hours, is 1/2 of the regular rate of pay. And this is how the Department of Labor does it, which is why I'm doing it this way here. Next slide. And of course, you just finish up by adding his straight time earnings to his overtime earnings in this instance. So his total pay is $475. So the second hypothetical, getting more complicated. So Ashley is a non-exempt sales clerk employed by creatively named Diamond Jewelry. She's paid $20 an hour plus commissions. And this week she worked 50 hours. It's around Valentine's Day, let's say, and she earned $500 in commissions. Now, she's just so happened, we'll throw this into, that she received an annual but discretionary gift from Ruby Jewelry worth $500. And then the question becomes how much she's entitled to. And let's, for those who are interested in giving it a shot, let's give it maybe a minute or so, Jason, and just let anyone who might be interested in seeing if they can come up with this, given with their calculators or on their phones, whatever they've got handy.
And Mark, a couple of people have submitted this via chat, so we do have some answers. We'll give it another 30 seconds or so.
Okay. Great. Do we have prizes? I didn't talk to you about that. I guess the prize would be...
I think you're going to give everybody a discretionary bonus, aren't you?
Well, that bonus will be good job done.
Okay, well, it looks like we've got a couple of responses in here, Mark. I don't know if you're looking at the chat feature.
I actually don't have that up, but...
Okay, well, I'm happy to throw in our answers from a couple of respondents.
Okay, well, that would be just fine. Do that.
Okay, well, we've got 2 people that have responded, both with the same answer. That, based upon their calculations, both have come up with the amount of $1,800.
Okay, well, let's see if that's right. No. So her total compensation for the week is $2,150. That's because her hourly rate and her commissions are included in her regular rate. The totally discretionary annual gift is not. So her total straight time earnings were $1,500. So she has a $1,000 weekly salary, which was the $20 an hour times the 50 hours that she actually worked, plus her $500 in commissions for the week, which was part of her remuneration for her hours worked. So that's $1,500. Go to the next slide. And that $1,500 converts to a regular rate of pay of $30 an hour. So you take that $1,500, or total straight time earnings, or total earnings before we get to overtime, and you divide it by the number of hours she actually worked, 50, and that comes up to $30 an hour. So now you've got the $1,500 component for her straight time, the 50 hours of just straight time pay. Then we have this $30 an hour regular rate to calculate the overtime premium. That half of that $30 an hour, or $15, which is the half of the time and a half, times her 10 hours, gets to $150. And then her, let's see, total compensation is $1,000 for, again, her straight time earnings, the $150 in additional half-time earnings, $500 in her weekly commissions, plus her $500 gift. And maybe that's what partly what threw things off is the question was actually framed in to what is she entitled to be paid, and that gift was part of what she's entitled to be paid. But so if that threw you off, that probably was unfair. That's a Department of Labor based example, so I'll if that takes a little heat off me. So this hypothetical 3, Joe this time, so he's non-exempt. He earns a weekly salary of $1,000, and the understanding with his employer is that that's intended to cover 40 hours per week, which is the employer's normal work week. And so in this week, Joe worked 44 hours. So how much is Joe entitled to for the week? So let's see, let's give another minute or two and see if anyone wants to take a shot at that.
So we've got a couple of responses that have come in. We'll give it another second or two.
Okay. Some people with vast math skills.
All right, Mark, I'll read off the 4 different responses. We've got 3 in at 1,150, and we've got 1 in at 1,180.
Okay, let's go to the next slide.
Which is the correct answer? Drum roll, please.
It is 1,150. So the majority is correct, and the employee of the last one, the 1180, is the happiest. But in this instance, so we have his total straight time earnings are $1,100. That's his $1,000 weekly salary for the 40 hours. That's the 40 hours that his salary is intended to cover gives a $25 hourly rate. And so he then, because that's what the agreement encompassed, and so that you determine that as his hour or regular rate, sorry. And you multiply that 44 hours worked by that $25 hourly rate, and you get an $1,100 base salary, plus the additional straight time earnings for those extra 4 hours. Then we do the overtime component, next slide. And since his regular rate of pay was $25 an hour, the total $1,100 that he earned divided by those 44 hours, his overtime compensation is $50, which is half of the $25 an hour regular rate times the 4 overtime hours that he worked, which then brings you together, total together at 1,150. So good job, good job. Then this hypothetical here. So this is the most complicated one here. Employees have a regularly scheduled work week of 8 hours a day, Monday through Saturday. They have a regularly scheduled work week that's 48 hours. I've seen this before in booming, economies or with just a lot of work to do. The extraction industries are one of those situations. In this example, the employees are paid at a rate of $24 an hour for their straight time pay. Now, the employee handbook, which is where an agreement or for expectation can arise for purposes of pay. Employees who report to work on a day they're scheduled and it's the show up pay and are sent home because of lack of work, they're going to be paid 4 hours of straight time pay. So you have an employee that works the schedule listed here. On Monday, he reports to work, or she, and is sent home without being given any work. So they're entitled to that 4 hours of straight time pay, even though they didn't work. Tuesday through Saturday, they worked 8 hours each day for a total of 40 hours actually worked. And so how much is the employee entitled to? And we would take another minute and just see, for those who are both brave and fast, if we can come up with this number on the fly.
All right, we've got a couple of responses in. We'll give it another 10 or 15 seconds. So far, our responses are unanimous.
So usually a good sign.
Okay, I think we've got consensus. All 4 respondents have a salary of $1,056.
All right,
Is that correct?
Let's see if they're right. Yes. So for everyone else who didn't already do the math, the 40 hours worked times their $24 an hour rate, $960. There was about 8 hours of show-up pay. I guess I said it incorrectly before. I'm not quite sure. I'll have to look back at that other slide, but $24 an hour, at least people read carefully, $96. Because the show-up pay isn't regarded as compensation for hours worked, it's excluded from the regular rate. So the employee's regular rate remains $24 an hour. And 40 hours times 24 gives you the $960, plus the 8 hours of show-up pay they were entitled to, that $96, gives you the $1,056. So again, great job, everyone. And then I thought wrapping this up is to talk about just a couple other little situations, but the end of the hypotheticals at least, I think. I guess it depends. There's at least an example, but you have situations where employees sometimes will work at different jobs for an employer that have different rates of pay. And so how do you handle that? And the default rule, and by default meaning it's the one that applies in every situation, and it's one that you can use in every situation. You'll always be fine doing that. Let's use a weighted average. And that you take all the earnings from all the rates during a week, you add them up, and then you just divide the total by the hours worked in all the roles. So the example here, Lori works 27 hours as a factory superintendent at $37 an hour, and she works an additional 13 hours as a trainer at $42 an hour. And so for a total of 40 hours, but the weighted average is $38.63, rounded up slightly at the last penny there. So you take the 27 hours, multiply it by $37, that gives you $9.99. Take the 13 hours, multiplied by the $42, gives you the $5.46. You add those two subtotals together, and you get $15.45. then you divide the 1545 by the 40 hours that she worked in this case, which brings you to $38.63. And this is, yes, I saw in the chat for clarification, this is for calculating it's for calculating the total pay that she's entitled to. In this instance, she did not work any overtime, and so it doesn't need to, we don't need to worry about her overtime rate because she worked just 40 hours. But you can extend that out, and if she'd worked more hours in one of those categories, then yes, you would get a different regular rate by the weighted average, whichever one you adjusted up or down. I mean, if she worked 30 hours as a factory superintendent and 13 hours as a trainer, then she would have worked a total of 43 hours, so she would be entitled to some overtime. Her regular rate of pay under this weighted average would drop slightly from the amount of $38.63 because should have worked a few more hours at that lower of those two rates of pay. But you basically follow the same process to get her straight time rate, regular rate, and then you would take that regular rate, divide it in half to determine the overtime rate portion, and you'd multiply that by those 3 additional hours that she worked, and then that would be her overtime pay added to her straight time pay, and then you'd get her total compensation, or what she's entitled to on her paycheck, minus, of course, taxes, withholdings, and deductions. So as a default method, this method can always be used. There is an alternative method that can be applied in certain circumstances, and that is to apply the regular rate or adopt the regular rate for overtime calculation purposes, the regular rate that is being paid for the work that's being performed when the overtime hours occur. So if you can track this carefully enough, you can use this alternative rate type of situation. So the employee has to perform 2 or more kinds of work. The employer has to have a bona fide, genuine hourly rate for those different types of work. It has to be paid, again, pursuant to an agreement or understanding, and the compensation, the overtime compensation must be not less than 1.5 times the rates applicable to the same work when performed during non-overtime hours. If you have, and the first requirement, the 2 or more kinds of work. So the jobs have to be truly different and not just the same job on a different shift, not a shift differential, the same job, night shift. That wouldn't work. So courts, these cases come from, or these examples come from court cases, but this requirement was satisfied when nurses worked different shifts that involved substantially different amounts of work that was qualitatively different. And I don't remember the specific facts from that case, but my general recollection, I think, was it something like, working in a neonatal unit and then different shift working as a surgical nurse. And it's, of course, satisfied, not surprisingly, I think, when employees whose regular jobs were bookkeeper or butcher or a maintenance person also came and cut the grass and picked up paper at the employer's plants on the weekends. Those are very different types of jobs. And it was also satisfied in a case where an employee worked the roles of a firefighter and a fire inspector, where there was really only a minor overlap between the duties in each role. I mean, the fire inspector wasn't putting out fires, for example, and someone would consider that a significant difference, but was also, when not fighting fires and acting as a fire inspector, was utilizing a different skill set and performing calculations and looking at essentially the clues. Or that would be post-fire fire inspector. For construction purposes, it's applying regulations and seeing if those are met in construction. So then going on to this, again, for the alternative method, I got the numbering incorrect, but the advance agreement portion, so it doesn't have to be in writing as long as the employee is aware of it before performing the work. So you orally inform them, that certainly would work. Or if the employee comes to you and asks to work the different role because for however they acquired the knowledge, they knew that the pay rate is higher, they talked to a coworker or something like that. Having said that, although it doesn't have to be in writing, best practices would be that the advance agreement should be in writing and with the writing signed by the employee, so it's very clear that the employee has seen that and implicitly, either explicitly or implicitly agreed to that by performing the work. And so that leaves us with questions. I don't know, I might be the only one who finished up early, perhaps by rushing things maybe, but I tend to usually run over, so I've tried to exercise some restraint.
Well, Mark, thank you very much for your time today. This was a great presentation, very interactive. So thank you very much. As we wrap up here today, feel free to submit any further questions via chat. I'd like to just, in closing, extend my thanks to all of you for joining us for our 33rd Annual Employment Law Seminar. As I sat here 1 year ago today in October 2020, when we were conducting our very first virtual employment law seminar, I thought, this is a one-time thing. And in 2021, we will be doing this in person. Boy, was I wrong. Hopefully, with any luck, next year we will be able to do this in person. But I'd like to extend, again, a thanks to all of you for your support, for being a part of this year's employment law seminar. I'd also like to extend a huge thanks to all of our presenters, and I want to name them. Kevin West out of our Boise office, Sean Monson here in Salt Lake City, Liz Mellum from Missoula, Montana, Christina Jepson, Susan Mott-Schiedler, Derek Langton, Jake Muklevitz, and Mark Wagner, all from our Salt Lake City offices. Great job to all of you. I will applaud you now and thank you for the materials that you've taken the time to prepare for this year's seminar. As I mentioned from the outset, a couple of logistical items. Due to the size of the file of the PowerPoint presentation, all of you are going to receive an email from me, very likely, that will include a link to go to our website to download the PowerPoint presentation. This should come to you tomorrow, so keep your eyes peeled for that. In that email, we'll also provide you with a link to yesterday's session and today's session. So if you have employees or members of your team that would benefit from this presentation, by all means, please feel free to share that with them. Separately, or individually rather, each of you will get an email based upon your registration preferences as it relates to whether or not you needed CLE credit or whether or not you needed HRCI credit. So we'll be sending each of you individual emails with that information. And with that, I'd just like to again thank all of you for being a part of this year's presentation. We hope you will join us next year for our 34th Annual Employment Law Seminar. And if you have any questions about any of the materials that were presented yesterday or today, please do not hesitate to contact any of our attorneys. And with that, I wish you all the best. Stay healthy, and we'll look forward to talking with all of you soon. Take care.
Goodbye.